Thank you.
SJC-11558, Commonwealth v. Carlton Haynes.
Yes, counsel.
Good morning, Chief Justice, and may it please the Court. My name is Hayne Barnwell, and I represent Carlton Haynes, who is the appellee FAR applicant. The appeals court reversed the single justice on the sole ground that no conscientious judge acting intelligently could honestly have taken the view that Mr. Haynes demonstrated good cause for not filing a timely notice of appeal. The appeals court was wrong in imposing rigidity on Rule 14, an historically flexible rule when determining good cause, and it was wrong to subvert the single justice's wide discretion, which she exercised, to find that Haynes's mistake in conflating a sentencing appeal with a convictions appeal should not deprive him of his direct appeal. The fundamental mistake, or the fundamental flaw that I find in the Commonwealth's argument is that good cause is somehow this segregated prong, this segregated inquiry, when really it's a very fluid, integrated one. So even if this court disagreed with Mr. Haynes that he had good, let's say a good excuse, let's say this court finds he didn't really have a good excuse, there's still that separate question which the single justice really focused on, which is the importance of the rights lost to the defendant. And here, of course, that right would be the right to judicial review to his direct appeal.
What role, if any, and you probably say none, but the fact that you found the appeal, notice of appeal from the conviction wedged into the file?
Wedged literally at the bottom.
So what impact does that have, or should that have?
I think, well, I did file a motion to stay the proceedings and go back to the trial judge. The Commonwealth opposed, and that's basically why we're up here now, because the Commonwealth opposed that. The appeals court agreed with the Commonwealth, and so the appeal proceeded from there. I think as a matter of judicial economy.
But the appeals court, didn't they have a footnote saying you could go back there?
That I could go back, but I think as a matter of judicial economy, this court could consider the issue even without the August 2012 notice of appeal and letter. But I think the Commonwealth doesn't dispute that Your Honors could also take that into account if you were to consider that today. That also gives further corroboration that he was trying his best to appeal his convictions. Did he make mistakes? Absolutely. Did the clerk's office make mistakes? Absolutely. Did I make a mistake in perhaps not finding that right away? Yes, I did. But as far as him, as a pro se defendant who's incarcerated, he really did everything he could to appeal, and certainly not, I know the Commonwealth focuses on, well, this was clearly a sentencing appeal. This wasn't an appeal of his convictions. Assuming Your Honors allow their expansion of the record on that, I would just note that if this had been a represented defendant, it would have been absolutely ineffective assistance of counsel for an attorney to believe that by filing a sentencing appeal, that means I'm filing an appeal of his convictions. And so the fact that he can't now raise his own ineffective assistance should not deprive him of his direct appeal. That's fundamentally unfair. And there's a great quote by the appeals court itself, not in this case, but in Subsaznik, where they say a pro se defendant doesn't have greater protections than a represented defendant, but he doesn't have lesser protections either. And so I think that directly applies to this kind of case.
But I want to make sure I understand. An individual, let's not take this case, an individual who chooses to represent himself at trial and does a pretty crummy job certainly can't then file a motion for a new trial based on his own ineffectiveness.
Correct. Correct,
that
exactly,
right.
and that's why I can't raise that in general on a motion for a new trial or today. But the operation of that rule, the reason why that makes sense is because, look, you chose to represent yourself. There's no ineffective assistance of counsel because you don't have counsel. But the operation of that rule shouldn't operate to deprive a defendant of a direct appeal because he makes the same kind of a mistake.
Isn't there, and maybe you've got them cited, but I'm recalling one or more cases within the last 5 or 6 years where precisely that has happened, that the counsel did not file the notice of appeal, and it's sort of well established. Am I right that there are cases where when counsel doesn't file the appeal and the defendant thereafter says, I didn't get my appeal, it's very likely that the appeal is going to get reinstated because it is ineffective assistance of counsel?
Correct, and the case on point on that is Commonwealth versus White. And Commonwealth versus White is also instructive, I found after reading it again, because the attorney there filed the notice of appeal late. I believe it was 33 days. It was, close in time. But the excuse, the Commonwealth really focuses on it should be sort of this unique or extraordinary excuse one has to give. But the attorney there just didn't understand that the 30-day clock starts, when the verdict comes down or the order comes down, and then it's not just by mail. In other words, if you file it within 30 days, if you mail it within 30 days, that's not enough. It has to be received by the clerk's office within 30 days, and the SJC goes on about that. Now, is that, anything other than an ordinary mistake by an attorney? I would say that's a fairly ordinary mistake. But that didn't deprive the defendant in that case of his right to appeal just because he made, say, an ordinary mistake versus a unique or extraordinary mistake. And that is the problem with the appeals court's opinion, is that it really harps on the Rule 60 type cases, Rule 60 of civil procedure, rather than Rule 14, which is far more flexible and far more generous given the stakes that criminal defendants have in pursuing their appeal and their availability of judicial review.
So what should be our standard with regard to a self-represented criminal litigant who fails to be timely? I mean, if it was ineffective, if he had an attorney to do it, but of course it's his own conduct, so what do we do?
What this court has always done, I would say in Commonwealth versus White, is instructive. I would also point to Commonwealth versus Trussell. I don't believe this court has explicitly stated like the appeals court has, but it's very persuasive that this isn't Rule 60 of civil procedure. This is Rule 14. And under Rule 14, a defendant, whether pro se or represented, does not have to show a unique or extraordinary excuse. I think that can be the standard. It can just be the general standard of good cause when it comes to a criminal defendant of any stripe, which is not even assuming that the excuse is not good enough, sort of, so to speak. The importance of the rights lost to the defendant is also important. The importance of a direct appeal must also be considered.
No, go ahead.
And then the other.
Well, if you're going to do a new thought, well, what if the shoe were on the other foot and the Commonwealth failed to file a notice of appeal late? Should we essentially extend then the same degree of flexibility we would have defended?
Fair, I think so. Fair is fair. Parties are both parties are entitled to due process, and so Barclay, which I point out in my brief, is a case on point.
But are they both entitled to mercy?
I'm sorry?
Are they both entitled to the same degree of mercy?
I was about to say Rule 14 is a vehicle for mercy on both sides, and Barclay is a great case on point. And I think the Commonwealth would certainly use it in their own defense, which is where the Commonwealth filed a late notice of appeal, and then the single justice took it up and decided, actually, you know what, that was completely inexcusable, Commonwealth. You filed it late, you have no good excuse, but because your appeal is important, because the availability of judicial review is important, we're going to allow it to proceed. So I agree. I think both parties have that vehicle under Rule 14 to use for their mercy. I didn't really go into the distinguishing points in Rashid and Haynes, and on further thought, I think I need to just briefly point out the differences there. In Rashid, it wasn't appealing the single justices of a late notice of appeal. It was a 211 Section 3 petition. And actually, let me go back. The real way to sort of resolve what are the main differences with Rashid and Haynes is that they never got it right. So not only did they not get it right the first time, they never got it right. So in Rashid, he filed a 211 Section 3 petition instead of appealing to the single justice. That was wrong. In Haynes, it actually didn't deal with Rule 14 at all. It was a 33E review. I think there's a footnote about Rule 4, but that's about it. And then at page 36 of Haynes, the court says, the defendant has never sought leave from a single justice to appeal the denial of his fourth motion for new trial. Whereas certainly he kept up his efforts. He actually, in August at least, filed it correctly, filed both the notice of appeal and the motion to file essentially late. And then I came into the situation, and then I filed, I suppose, another notice of appeal, and then I filed the motion to enlarge in the single justice. So at some point, we got it right. So that's-
And the motion for new trial is still pending?
It is still pending. There's an argument hearing on May 21st, and I informed my sister of that.
Thank you.
Good morning. May it please the Court, Assistant District Attorney Amanda Teo for the Commonwealth. Your Honors, I'm asking this Court to assert the continuing vitality of Rule 14b and also to give some instruction both to litigants as well as the single justices of the Appeals Court as to how to apply this Court's rules, particularly Rule 14b, in a criminal context. Here, what I think is important to focus on is what was the record before the single justice. The Commonwealth is actually making a two-pronged argument, as it were. One is that a defendant who is pro se cannot simply say, oops, I misunderstood, and thereby demonstrate good cause. But the first thing, and the most significant thing, is what that defendant, now represented by counsel, needs to show before the single justice in order to obtain in order for the single justice to grant an order grant his motion for a late filing of a notice of appeal. What was before the single justice here was only an affidavit from appellate counsel, stating that the defendant was confused. And that affidavit actually was internally contradictory in that it also said that the defendant, even though he thought that the single document that he filed, which was an appeal from sentence, also constituted his appeal, his direct appeal, he nonetheless subsequently wrote to the clerk's office asking why his direct appeal had not been docketed. So even that affidavit does not support the proposition that the defendant was confused that one document sufficed for both purposes.
Could I ask you a question?
Sure.
Do you think the same rules should apply with respect to interlocutory appeals by your office from motions to suppress?
I think there is an open issue there before this court, obviously,
Yes,
in
there
Jordan.
is.
And I think the issue in Jordan is slightly different. There, the issue is whether or not Rule 15 allows a single justice to ignore or cure deficiencies.
Without a motion at all?
But I think in Jordan, if I understood the record correctly, the Commonwealth actually conceded that that there was no notice of appeal. But the question was whether or not a single justice of this court, hearing a petition under Rule 15, could then cure that deficiency, even though there's an obvious deficiency. So I think it's a somewhat different issue.
Well, how about when you file a motion to file an application under Rule 15 late and there's no affidavit from the Commonwealth's office?
I think it is best practice for the Commonwealth's office to file an affidavit, but I think certainly from our office, when we do make an application that is late, we do state either in the body of a motion, affidavit-like, or in a separate affidavit, the reasons why the petition is late. And I do think that in the interest of fairness, all litigants should be held to that. I think that's the crux of fairness, is that a rule apply equally to all litigants.
And you
So
do.
you think a no mercy rule should be applied here and then applied equally to your office when you fail to meet a deadline? And you'll abide by the no mercy rule?
That is correct, Your Honor. I think Rule 14, first of all, I would say that Rule 14b is it's rather capacious to read it as a rule of mercy. What I read it as is a rule that is mandatory and jurisdictional. It is mandatory and jurisdictional in the sense that it sets the outer limits for when a judgment should be final. And the reason for 14b, the reason why this court
More
enacted—
than a year, was it?
I'm sorry?
This wasn't more than a year, was it?
No, it was not.
So isn't that the jurisdictional issue?
That's correct, but I'm saying that Rule 14b, the objective behind it, and the reason why the rules of this court say that there should be no exceptions from Rule 14b is because it is important to have finality in cases, that the Commonwealth, the courts, the parties, the victims, all have an interest in finality that Rule 14b codifies.
But wouldn't you also agree, though, that our system thinks that the right to appeal from a criminal conviction is extremely important?
Absolutely, Your Honor. But I believe that here, let's go to the Barclay standard of the importance of rights lost. Are there really important rights lost here? The crux of what this defendant wanted to bring forth in his direct appeal are claims that can only be raised by the vehicle of a Rule 30 motion, and he will have the opportunity to, should he get an adverse ruling on that motion, to bring that to a review of to have appellate review of the Rule 30 motion. And I think that's the problem here, Your Honor. Before the single justice, there was a very meager presentation of what constituted good cause and what were the importance of rights lost here. This is not a defendant for whom his important claims are not going to get appellate review because of his not being able to pursue a direct appeal. Rather, this is like a defendant, for example, in Cowie, who is going to be able to pursue a Rule 30 motion and then have appellate review of the consequences of that motion. I guess what I'm asking this court to do here is not necessarily just to say that a pro se litigant does not demonstrate good cause merely by misunderstanding the rules of court. But I'm also asking this court to provide some guidance as to what a defendant or what the Commonwealth needs to show in order to obtain permission to file an untimely notice of appeal. Before the single justice, the presentation was so meager. And the meagerness of that was only highlighted by all of the documents that came in after oral argument in the appeals court. The fact that these documents were available in the clerk's file, the fact that the defendant was his own counsel and could have presented an affidavit but chose not to. All of these are reasons why the single justice abused her discretion in finding good cause, even if this court were to believe that a pro se defendant should be given wide latitude in the definition of good cause. Now, furthermore, I would like to reiterate that if this court were to find that a pro se defendant, just by virtue of being pro se, has good cause for filing a belated notice of appeal, then that would be very much inconsistent with the precedent that this court has set throughout the years. In Haynes, in Rashid, in Broussard, Salamine, and also the Supreme Court in Jackson, time and time again, this court, as well as the Supreme Court, has said that pro se litigants bear the risk of deciding to proceed without an attorney, that they are not protected if they, for example, default on claims by failing to object at trial, or they fail to comply with other rules of
Do you read the
appellate
defendant
procedure.
as arguing for a complete evisceration of the sort of principles that you're arguing about? I mean, I didn't think that was her argument or his argument at all.
I do not, but I think that's a natural consequence of the argument that he, by virtue of being pro se, well, I would say that's a natural consequence of saying that I was mistaken and that constitutes good cause. Because certainly if this were a situation in which, if it was a civil litigant, that would not be enough for...
If counsel had said, I was mistaken here, you know, I thought that filing what I filed was enough, and corrected it in the same time frame, would we say, sorry, you're bound by your counsel's mistake? Not likely.
Well, I would say two things. First of all, if that were the case, I think there needs to be fact-finding below and the ability to present, and holding a defendant to having to actually present evidence to show that his counsel made him aware of his right to appeal. He wanted to perfect that appeal, but counsel did not, in fact, perfect that appeal. There has to at least be that showing. But secondly, I would say, yeah, absolutely, that's still not good cause. Now, this court, in its wisdom and mercy in White, said that when it comes to criminal cases, you can consider other things in deciding whether or not to grant a late notice of appeal. Those other factors include the importance of rights lost and the interests of judicial economy. But in this particular case, neither of those factors actually militate in favor of the defendant's position. Again, the rights lost are going to be negligible, if any, because all of the claims that he wishes to present are going to be presented in his Rule 30 motion.
I thought there were other claims that were alluded to in his request.
And I think alluded to is correct, Justice Duffley. The only other issues are referred to in 3 words, such as suppression. And that, again, goes to the meagerness of the presentation before the single justice. The Commonwealth is not saying that a defendant who has made a more full presentation before the single justice could not obtain relief here. All I'm saying is that based on the presentation that was there, this was a pro forma grant by the single justice of a motion to file a belated notice of appeal. It is not a meaningful one. And in order for Rule 14b to really have teeth, then there needs to be more. Then at the very least, a defendant has to present his own affidavit explaining why he chose not to file a notice of appeal
We'll
on
have to
time.
leave it there, counsel.
Thank
Thank
you,
you
Your
very
Honor.
much.
All rise.